Today's episode is brought to you by Mazars.
SoundCartel.
From SoundCartel, I'm Nicole Goodman, and this is Business Essentials Daily. When it was first announced, the right to disconnect law was met with angst from many who thought it was unnecessary and could lead to increased disputes among employers and employees. The rules take effect for some in August this year. Small business operators have another year to wait. To explain the new rules and what to expect is Cheryl-Anne Laird, head of the HR and IR division at Mazars. Chris Ashmore begins by asking Cheryl-Anne whether there's any truth to the assumption that employers could face criminal sanctions as a result of the new law.
This was an error that was made in the drafting, which will be rectified. There is no intention that I'm aware of for criminal sanctions to apply in relation to the right to disconnect.
So what is the right to disconnect when it does come into effect?
Eligible employees will have a right to disconnect outside of work hours. Essentially, employees will have the right to refuse to monitor, read or respond to contact or attempted contact from an employer or a third party outside their working hours unless that refusal is unreasonable. The right to disconnect will become part of the general protections provisions of the Fair Work Act. These new rules will apply to employers generally, so other than small business employers, from the 26th of August 2024, and then to small business employers 12 months later on the 26th of August 2025. Rules will then also apply to determining when an employee's refusal is unreasonable. What we're not completely clear on now is what constitutes contact, because that is not defined. However, it is expected that will be given a broad interpretation and include attempts to call an employee, text them, email them, use any of the myriad of messaging services which are available, such as Teams or WhatsApp, and essentially any effort to engage an employee outside of their normal working hours. An employee can, under these new provisions, simply refuse to engage with the employer if that refusal is reasonable. The new provisions do not exhaustively set out what will be considered in determining if a refusal is reasonable. However, certain factors must be considered, and these are the reason for the contact or attempted contact, the mode of contact or attempted contact and the level of disruption it causes to the employee, whether the employee is compensated, including by non-monetary compensation for working outside of ordinary hours, the employee's role and level of responsibility, and the employee's personal circumstances, including family or caring responsibilities.
What if an employer and an employee cannot agree on what is reasonable?
Yeah, the changes to the Act also include a new dispute resolution process. Where an employee has refused to engage with an employer, the employer and employee must first attempt to resolve the dispute at the workplace level through discussion between the parties. However, if the matter cannot be resolved at that workplace level, the employee may escalate the dispute to the Fair Work Commission. The Fair Work Commission has new powers to make orders that the employee stop refusing contact or that the employer stop certain actions, such as stop contacting the employee, stop taking disciplinary action against the employee arising from their refusal to engage.
Right. It all seems quite technical, particularly for small business owners. What will be the practical implication of these new provisions?
Unlike what I think has perhaps been perceived as the meaning of these provisions are not a prohibition on an employer making an attempt to contact their employees outside of regular hours. However, taking any retaliatory action, such as disciplinary action or other employment detriment when an employee declines that out-of-hours conduct, will then become the breach of the Act. So employers may still try to make contact where they absolutely need to. That is in itself not an offence. What is an offence is if you then take action to the detriment of the employee if they elect not to engage. So the right is with the employee to elect not to engage with any attempt to contact them outside of working hours. Employers are now going to need to consider what alternatives might be available to them if they feel the need to contact somebody outside of working hours and that employee elects to decline to engage in outside of work hours contact. And from a practical perspective, this is going to be particularly challenging for international businesses who expect Australian employees to participate in meetings and calls outside of the Australian normal working hours.
Absolutely. Now, August is just around the corner. What can business owners do now, between now and then, in preparation?
Now is the time to start consulting with your workforce so that everyone is clear about what the expectations might be come August 2024 about out-of-hours conduct. They should also be reviewing their contracts to make sure that the expectation about working hours is clear, remembering, of course, that the National Employment Standards provides only for 38 hours per week plus reasonable additional hours. They need to develop or refine their policies regarding out-of-hours contact, and they need to ensure that all of their recruitment processes are clear on what might be considered to be out-of-hours contact requirements, which will form a legitimate part of the role. For example, if you're being recruited into an international firm, it's only fair that you know up front what those expectations might be to attend meetings, take calls from other time zones which may not align with yours. And also if you're joining an employer who might have emergency needs outside of normal working hours, what will be the expectations on individual roles to be that emergency out-of-hours contact? And define and refine, if you already have them, the protocols to be used where out-of-hours contact may become necessary.
What do you think, Cheryl-Anne? Do you think the current trend to flexible work hours might create some challenges with defining out-of-hours work?
I do. Personally, I think that the introduction of guidelines for what might constitute out-of-hours work, which is what employers should be working on now in preparation for the introduction of the new right to disconnect, may well open a Pandora's box about some of the current flexible work practices and their compliance with awards and enterprise agreements, particularly around things such as spreads of hours or overtime provisions. But this is speculation on my part at this stage, once we understand what is actually happening out there with hours of work.
That was Cheryl-Anne Laird, head of the HR and IR division at Mazars. This episode of Business Essentials Daily is produced by the team at SoundCartel. Thanks for listening. I'm Nicole Goodman. We'll bring you more Be Daily tomorrow. Follow at BE Daily Podcast across social media and head to bedaily.com.au for more from the Business Essentials Daily podcast. SoundCartel. This episode was brought to you by Mazars. To find out more, visit mazars.com.au. That's mazars.com.au.